and thank you for joining us today. The title of today's presentation will be RIA Registration 101. My name is G.J. King, and I am the president of RIA in a Box. We are an RIA compliance and registration consulting firm. One of the areas we specialize in is helping guide new RIAs through the entire registration process. We've helped over 2,000 RIAs get registered since 2005. So this is something that we're very familiar with and take very seriously, and really excited to have you with us today. Just spend a few minutes kind of giving you the quick basics about the RIA registration process. A few quick things as far as disclosures before we get started. RIA in a Box LLC is not a law firm, investment advisory firm, or CPA firm, and does not provide legal advice or opinions to any party or client. You should always consult the relevant regulatory authorities. And also, this presentation is not intended in any way to be a comprehensive overview of all relevant regulation. This presentation is for educational purposes only and should not be relied upon to take any actions. So with that, maybe we'll dive in here a little bit and just give you the quick basics on the registration process. One question that comes up quite a bit is, what is Finra's involvement with the regulation of RIAs? Many of you may be coming from a broker-dealer world where you're very familiar with Finra, and just to clarify, Finra does not regulate RIAs. What Finra does do is administer the online filing system for the RIA registration process. The registration process does require the Finra entitlement application, which is administered really through a paper format. And Finra also facilitates fee payments to the SEC and the states. So think of Finra in many ways as really kind of the software administrator to what's going on here. So if you're working with the SEC on the left-hand side, Finra will help kind of administer some of the back and forth with the SEC. If you're working on the right-hand side here with any of the states where you see kind of the NASA logo there, which is the North American Securities Administrators Association, in a similar fashion to the SEC process, Finra is going to kind of be helping quarterback that process with NASA. And of course, where a service like ours comes into play is we are kind of interacting with the Finra system, directly with the states, or directly with the SEC, all on behalf of our RIA client. So that's just something hopefully to keep in mind as far as Finra. So again, just to reemphasize, Finra does not regulate RIAs, but they are a bit involved with the registration process, given that they administer the online filing system for RIAs. The basics in terms of the registration process, really the first thing to think about is it going to be an SEC or a state registration. And the general guidelines are as follows. Generally, if you have $100 million or more in assets under management, you're going to register with the SEC. If you have less than $100 million of assets under management, you're generally going to register with the relevant state or states. There are a number of exceptions to these rules, but some of the common exceptions would be as follows. If you're located in the state of Wyoming, you're automatically going to register with the SEC, as the state of Wyoming actually does not sponsor its own registration or examination program. So regardless of AUM, you're going to register at the SEC. New York also has a slightly different threshold, where in the sense that if you have $25 million or more in assets under management, you're actually going to register with the SEC. And this is kind of a legacy to the Dodd-Frank legislation from a few years back, where most states bumped up their limit from $25 million to $100 million, but New York is still participating at the old $25 million threshold. Some other exceptions would be if you're an advisor to an investment company. In other words, if you're advising a mutual fund, for instance, you would register at the SEC. Or if you'd be required to register in 15 or more states, you also would register with the SEC. And a common situation where this comes up is if you are a financial planner, and while you may not have traditional assets under management per se, you may have clients across the country which will require you to register in a number of states. So at that point, if you're going to be over 15 states, you are able to register at the SEC. And the last one here is the Internet-only advisor, which is permitted to register at the SEC. And just to emphasize here, this is generally a pretty limited scope as far as what an Internet-only advisor is, and definitely something to explore a little bit further before you assume that you'll just be an Internet-only advisor. Some of the common state registration triggers to keep in mind here. If you have a physical office in a state, it's going to require registration with that state. That also includes a home office. In terms of clients, most states require registration beginning with the 6th client. There are some exceptions, for instance, where Texas and Louisiana require registration with the first client. Solicitation. Generally speaking, active solicitation requires registration. Some common acts of what we consider to be solicitation would be if you have a website that you're kind of marketing to the public, if you have quote-unquote boots on the ground where you're going into a state and hosting a seminar or doing things on the ground, or if you're just doing kind of some outbound marketing into that state, be it via mail or any other kind of similar method. A couple of things just to highlight about the state registration process. Most states have a similar process, but there are some nuances that are a bit different. A couple of things to keep in mind here is every state may generally have kind of different supplementary state filing requirements. And what we mean by that is they're going to require some additional documentation. This may be a balance sheet, fingerprints, affidavits. They really can kind of run the board across what they may be, but they are going to vary by state. Some states will also have an advisor experience requirement. It's not all too common, but for instance, the state of Minnesota and state of Connecticut have requirements in this spirit. And also charging performance fees is going to often vary by state. Some states may allow you to only charge this on an annual basis, only charge it to qualified investors, and there are some states that will not allow you to charge performance fees at all. The process, beginning the process, you need to make sure all the fees are paid to the relevant states. In general, this for most new RIA firms will only be a few $100s. It's not an immense expense. And then also just to keep in mind that the individual investment advisor representative registration is also administered at the state level. So the individual registration is going to be a separate process from the firm registration, and we'll dive into that a little bit later. States will vary as far as the time they generally take, as far as how long it takes to be approved. But generally speaking, you should budget in about 1 to 3 months before your RIA will be approved at the state level. Looking at the SEC process a little bit, one thing to highlight here is this 120 days. So many new advisors are not going to have 100 million of assets on day one. So the SEC gives you 120 days to reach SEC registration eligibility. So in other words, you have 120 days to get up to 100 assets in management when you're kind of transferring those assets over when you're first starting your RIA. One thing to note is the clock begins on the registration approval date. And if you don't hit that within 120 days, that 100 million threshold, you're going to need to down transition to the state level. As far as the process, again, the fees are going to be paid to the SEC and the relevant states. Some SEC fees to keep in mind is generally if you're over 100 million assets, you're going to pay $225 on an annual basis. If you're below that, you may pay $150 or less. You're also going to have to pay notice filing fees to the states, even if you are an SEC registered firm. And those, again, can range from a few $100s to a little bit less. It really varies by state. One thing to keep in mind here is, as I mentioned before, the individual investment advisor representative registration is administered at the state level. So even if the firm is registered at the SEC level, the individuals of that firm are still going to be registered at the state level. As I discussed a little bit earlier, you're also going to need a notice file in the relevant states. And the SEC registration process generally takes around 1 month, but there can be some variance around that, so just to keep in mind as far as budgeting time. Just to touch on some of the big documents that are part of the firm filing when it comes to RIA registration. The main document is your Form ADV, and it gets split into 2 parts for the firm. It's the Part 1, which is kind of the basic firm information, and this is the online component of the form. And the Part 2A is more of a narrative brochure that's going to describe the firm's services, fees, and things like that in a more of a narrative format. Some other kind of firm operating documents that you're going to need to have as an RIA from day one, first of which would be the Policies and Procedures Manual. And this really is your most important ongoing compliance document. That's really going to be how all your ongoing compliance is driven through. And it's really important that this is tailored to your firm, but it really matches your business practice so that it's relevant. Some other forms and kind of internal documents you're going to need would be a code of ethics, a business continuity plan, the proper investment advisory contracts, and of course some privacy policy statements as well. As far as the individual investment advisor representative registration process, there are some licensing requirements that generally come into play. So the first option here is you need to pass the Series 65 exam or have previously passed the Series 66 and Series 7 exam. And the nuance with that Series 66/Series 7 combo is that if you have held both these licenses before, you're going to need to have been affiliated with a broker-dealer generally within the last 24 months. So if you've left the broker-dealer and you previously had these licenses, as long as it's been within 24 months, you should be fine. If it's been longer than that, you may be required to now take the Series 65 exam. And another way to exempt yourself from having to take any exam would be to have a professional designation, which would be perhaps the CFP, CFA, CIC, CHFC, or PFS. And as we mentioned before, for instance, in Connecticut or Minnesota, there occasionally are some experience requirements that come into play. Another thing to note is every RIA firm needs at least one IAR. And what we mean by that is every firm needs at least one individual affiliated with the firm. Again, you're going to need to pay kind of the fees to the relevant states on an annual basis. Most fees when it comes to individuals are less than $100 on an annual basis, but it does vary by state. You're also going to need to submit the individual's Form U4 and ADV Part 2B. And this is also administered generally through the Finra system. And then as we mentioned before, just one thing to further reemphasize is even if you are an SEC-registered firm, you still need to make sure that your individual investment advisors are properly registered at the state level. And just to wrap up here about our company a bit, we help RIAs stay compliant and better spend their time. We've been doing this for a long time. As I mentioned before, we've helped set up around 2,000 RIAs. We also offer ongoing compliance consulting to many of our clients as well. So this is something that we know very well, we really take seriously, and are really excited to kind of help you with if we can ever be of assistance. And just touching upon our Lexington compliance offerings. Lexington Compliance is our ongoing compliance consulting division of RIA in a Box. And it's staffed by ex-state regulators, and we offer monthly compliance programs beginning at about $59 per month. And we really have designed these programs to fit every investment advisor's budget, regardless of their complexity. We really can tailor a plan that fits you. And again, we really appreciate you listening in today. We hope this has been a good, brief overview of the registration process. Please do understand this is, of course, not intended to include every little nuance, and it's really important to really understand your particular situation. But we do hope this kind of outlines some of the basics and has clarified any initial questions you may have had. Of course, we really strongly encourage you to contact us. You can find us on the web at riainabox.com, or you can call us at 866-611-7638. And again, we really appreciate you taking the time today to join us, and we really hope we can be of assistance to you. And again, if this is something that you're seriously considering, we're really excited for you and really strongly encourage you to take a deep look, because we've really seen this model thrive and seen so many people really enjoy making this transition. So again, we